Matter relates to my lord. Your lordship has previously taken up this matter. My appointment was cancelled in respect of classes 9, 10. Participated in upper primary. I was merit listed. My male female rank was 24. My female rank is 7 in both general as well as my.
Now, you participated 2006
Yes,
SLST, first SLST 2016, 9-10
9, 10 as well
and
as
upper primary. Just a minute. Now, thereafter, where you called for
yes, yes.
counseling in the first round, in the previous
yes,
round?
Yes, yes, my lord.
Yes.
If your lordship, first I am showing my rank, my lord, page 67.
Yes.
My lord, serial number 61, your lordship kindly comes, the multiple ranking is there. 67.
Against which serial number?
My lord, 61.
61.
My lord, there are, kindly see all the names is the
Just a minute.
petitioner, multiple ranking.
Male, female under general category 61 rank.
And no, not 61. Rank is, my lord, on the right hand side. Kindly see.
Yes, 61.
Yes, 61. Thereafter, my lord, kindly see the next. Only female general, OBC male, female, all in all, everywhere I have my
Then
rank.
male,
Yes.
general category 24.
Yes.
Then male, female. It is male, female. 10 means.
My lord, is OBC code is the code, my lord. I am an OBC B candidate. 7.
Then what is 1?
My lord, 1 is general.
MF 161.
My lord, it's general.
General. Then F1 24 is general.
General.
Then MF 10 means.
My lord,
OBC. OBC B.
OBC B. My lord,
yes. This is your rank in connection with first SLST
upper primary.
2016 upper primary.
My lord, next page.
So why you did not appear in the previous round of counseling?
Yes, my lord. Page 68.
Case of a candidate who has multi-ranking, against which vacancy the petition was formed. That petition is not relevant that I was in 4 panels. The call which you got, the intimation for counseling, against which category you got. Because in the other categories it might not have used. So that the petition should be made.
No, that commission will consider. In terms of merit, if petitioner comes within the zone of consideration,
we are dealing with lakhs of candidates.
But it is to be fed in your computer.
Each candidate,
Mr. Dr. Patro, it is to be fed in your computer and you will get the answer.
lakhs of candidates they will just casually come.
No, it's not. Dr. Patro is not a casually they are coming. They are being forced to come.
But the manner in which they are coming, firstly the delay, I will argue that I don't want to interrupt my knowledge friend. Firstly the delay. Secondly, you are not giving the proper data before the court. If you give the proper data, I can come with the proper instruction. Now I have to check all 4 categories whether they were called. That's why I have to check the roster point. You have not mentioned anything.
Who is responsible for that, Mr. Dr. Patro? No, for cancellation of SLST 2016. So that is the reason they are coming to today. Because the petitioner is pitted against all odds.
Data the petitioner has access to. The petitioner knows against which category the petitioner was called, which panel against.
Yes, now when you were called for interview.
Next page, page 68.
Yes,
my lord, it's pure science, my lord. I am a pure science. My lord, your lordship will see 1, 2, 3, 4, 5, 6, 7th, my lord, for pure science.
Yes, pure science.
My lord, up to 400, the date was also there.
So you are within 400.
400 in every category, I am within 400.
Because 61, 24, 7 rank.
And my lord, why I did not, that also I have annexed. I was blessed with a baby, my lord. Thereafter, I was serious complications. My medical report, I have also.
So you have not lost the job?
Yes, I have lost the job. And thereafter, my lord, by pursuant of the order passed by the Honorable Supreme Court, since I am a candidate found not to be tainted, I have been allowed to go to school.
And you are receiving salary now?
Now I am receiving salary.
Up to 31st of December 2025.
I have the document also, my name is.
So I have already passed an order.
Yes, my lord.
Let me pass the same order. But in the meantime, situation is changed.
My lord.
Today, tomorrow is the date for counseling. What can be done?
My lord, this is the order, my lord.
May I distinguish this?
This is the-
Firstly, the petitioner, what he has not pointed out, though he has added it, he appears in the personality test pursuant to an instrument of personality
Yes.
code.
Yes, I have.
His appearance is totally subject to the result of that particular petition.
My lord, even I have to say something. They have accepted. It's a matter of in-service, my lord. Let me then complete, my lord. I thought it would not be taken up. Initially, in-service candidate, my lord, if that be taken up, then what is the stand I am?
So he participated, petitioner participated.
Your lordship passed an order, my lord. My lord, I am telling your lordship, initially, in-service candidates were not allowed in spite of order of court. Thereafter, again, I approached this honorable court. This honorable court, your lordship passed an order
On
directing
23rd of April.
page 61, my lord.
Oh, previous round of litigation.
Yes, yes.
Page 60.
One. Kindly see. They allowed in-service candidates, every in-service candidate. But for me, I have to approach this court because they are not following their own order. Your lordship granted me liberty, and thereafter, in final merit,
Just a minute. Now, whether they are permitted to participate in the personality test petition.
But the affidavits were exchanged way back in 2021. Deputy was there to mention. For the past 4 years, has my lordship taken any steps to secure, or you waited for the next?
my lord, they have accepted this order finally. I have
No,
the
but
order. They
if the
have-
petitioner was permitted to participate in the personality test,
Yes.
now thereafter why petitioner will be left out? Will not be permitted to participate in the counseling.
Decided that whether if I go on giving step after step without coming to a final conclusion with regard to a particular one, by way of an interim order, you appeared in the personality test. Way back 2021. Panels came out in September 2024. You fact that you did not let my lordship show that he had mentioned at least once. Liberty to mention after 6
So let
weeks.
me direct that both the writ petitions to be heard together.
Yes.
But in the meantime, permit the petitioner to appear in the
Then they should go last
in the
session.
counseling if he comes within the zone of consideration and if the petitioner is untainted candidate.
Yes.
Just one point, kindly, if my lord passes that order, yesterday's order, there is a slight misrecording that my lord has stated in yesterday's order that it is the stand of the commission that they will not allow absentee, but that is not what I had said. It is our rule. Our specific rule is that if you are absent at the time of counseling, you will not get a chance. The rule is annexed to the writ petition. It clearly states that if you are absent.
Very
Now-
well. That is to be incorporated in today's order.
Yes.
Yes.
And the petitioner, my petitioner, rest of the child, I do not want to say things very harsh. But the counseling was, when the counseling was being held, the baby was 2 months.
No, I am not entering into this issue because yesterday.
No, I said that I have pre-pregnancy complications, my lord. Post-pregnancy complications I have annexed.
So that,
My lord, I have my medical.
Now, if court today proceeds on the premise that petitioner has lost the job, and that the order which I have passed yesterday, There is as a special case, since petitioner has
Your
lost the job,
lordship,
let the petitioner be permitted to participate in the counseling.
job cannot be the reason for coming into this selection process. This is not a selection process which is tainted. This was also.
Why, Dr. Patro?
my lord,
Just a minute. Why, Dr. Patro, court will not draw inspiration from paragraph
please, sir.
47 of the order of the Honorable Supreme Court
Because,
dated 3rd of April?
because of two reasons. Firstly, they were in service candidates who left their jobs and joined. These are candidates who were not in service.
Directed, if necessary, supernumerary post is to be created, are to be created.
Yes, that is for those who lost their jobs. But here, there is no supernumerary post for the person who is now going to be deprived. If I allow it,
If I am not directing the commission to dilute the merit. If in terms of merit, if he come within the zone of consideration, so there is no wrong in ousting one candidate who is in terms of merit lower than me.
if I am drawing inspiration from the Supreme Court judgment, then I have to look at the entire pattern. What did the Supreme Court say? That if you had a job you were previously working, you can go back. When you go back, if you see that that job has been occupied by somebody else,
Then supernumerary post.
post will be created for that person.
And this is a case. This is a case, Dr. Patro, where petitioner participated in both the selection processes.
Here,
And in both the selection processes, petitioners were selected. Now, petitioners were working in secondary or higher secondary sections, which in terms of emoluments and salary is a better option. So far, petitioner is concerned. Rightly, she or he decided, candidate decided to stick to the appointment in connection with first SLST 2016, class 9, 10 or 11 and 12. Now, ultimately, because of the misdeeds of the School Service Commission, yes, no, you have to take the responsibility. These candidates have lost the job. These candidates have lost the job. Now they are selected in another selection process, and they are coming within the zone of consideration in terms of merit. This is a better situation which is before me than the situation which was considering by the Honorable Supreme Court, and an order was passed on and the direction was observation was made in paragraph 47 of the order dated 3rd of April.
that guy got prevented from coming and participating
Yes,
in
yes.
the counseling. Their recommendation letters have been valid for 3 months. They know this. They could have participated in the counseling.
Yes, sure.
So, only one thing, I just conclude one last sentence, my lord.
Yes.
That is the Supreme Court, by directing supernumerary posts, they actually protected those candidates who have suffered due to these candidates coming back. But here there is no protection.
Yes, it is a better case that petitioner has lost the job, but at the same time, on being selected, since you are taking the point that they are absentee candidates, they should not be permitted. Why they remained absent, Mr. Dr. Patro? Why they remained absent? Because they are in service candidate at the material point of time, and ultimately, you are not able to produce before this court who are tainted and who are untainted. As a result, whereof Supreme Court had to set aside the entire selection process.
I'm not disputing anything, but they were not in service because Justice Bosak sitting in the division bench had already terminated.
Petitioner cannot be penalized at both ends. I am not saying that diluting merit you permit them. I am saying that if they come within the zone of consideration in terms of merit, permit them to participate in the counseling.
Only one.
Take a sympathetic stand, Dr. Patro.
Kindly record the order two things. One is that absentee candidates will not be permitted. That is as per the rule. That is not a policy of ours, it is the rule. And the other aspect is that the petitioner participated for this petition. I'm saying participated pursuant to an interim order passed in the district application. Let these two points be recorded.
Here the orders, if certain corrections are required. So no, it is a similar order. Basically,
only one thing, I have that list. Will I give that to your lordship?
list of
The DI has sent that to my school where my name is appearing.
very well. That I have recorded, and I have directed the commission that if you are coming within the zone of consideration in terms of merit, and if you are not tainted candidates, you will be permitted. To that extent, Dr. Patro made my job easy yesterday. শোনো এইগুলো না সুবিধের জন্য অপশন গুলো রেখে দিয়েছি, বুঝলে? এক্ষেত্রে তোমার হবে দিস ইজ এ কেস অফ ক্লাস 9 and 10
9 and 10, man.
ক্লাস 9 and 10 মানে তুমি এইটাকে ধরে পড়বে 9 and 10 এইটা থাকছে না, 11 12টা থাকছে না। যেমন ওয়াজ ওয়্যার, এটা যেমন ওয়াজ হবে একটু করে নেব। Yes, yes, it was a single petition, but I have to made certain pencil corrections because I know that today there are matters where more than one petitioners are coming. Needs to be correct. তো সব জায়গায় এই 9-10টা হবে, বুঝতে পেরেছো? 11-12টা হচ্ছে না।
আগে read করতে মিস বাইরে এসব অন্ডারভিস ছিল আপনারা একটু
অ্যাজ এন হবে
রাইট ছোট্ট
ইন সেকেন্ডারি, এইখানে না এটা সেকেন্ডারি হবে, হায়ার সেকেন্ডারিটা হবে না 9-10।
তো মেনে নিচ্ছি সেশন
in secondary sections rather than